Hi, thank you for coming back. While you're eating your lunch, we're going to have this first panel on immigration. There's two panels on immigration this afternoon. I'm Professor Christina Campbell. I teach here at UDC and I direct the Immigration and Human Rights Clinic. So our first panel today is Professor Mark Noferi and Erin Corcoran. And so I'm going to introduce them and then hand it over to them. So Professor Noferi has taught at Brooklyn Law School since 2010. He teaches a seminar on immigrant civil rights, serves as faculty advisor to the Brooklyn Law School Immigration Court Observation Project, and chairs the detention subcommittee of the New York City Bar Immigration Committee. His research interests focus on immigrants' rights, with a particular focus on immigration detention and access to counsel issues. His most recent article, Cascading Constitutional Deprivation, the Right to Appoint a Counsel for Mandatorily Detained Immigrants Pending Removal Proceedings, was published in the Michigan Journal of Race and Law in winter 2012. I have to say it's an excellent article. He is also conducting research on immigration detention risk assessment practices, and he co-authored a recent op-ed in the Baltimore Sun, Unlocking Immigrant Detention Reform. Before joining Brooklyn Law School, Professor Noferi was a public interest fellow at the Seton Hall Center for Social Justice, where he supervised clinical law students on immigrants' rights, civil rights, and national security-related litigation. Among other matters, Professor Noferi supervised constitutional challenges to Immigration and Customs Enforcement home raids in New Jersey on behalf of Latino residents, and wage and hour litigation for immigrant day laborers. Our second panelist is Professor Erin B. Corcoran. She is at the University of New Hampshire School of Law. She's the Institute Director of the Center for the School of Law's Law and Social Justice Institute. She also teaches immigration law, administrative process, and international human rights law. She was appointed to the New Hampshire Supreme Court's Access to Justice Commission in 2011, whose mission is to implement changes to improve citizens' access to courts, in part by fostering the development of a statewide integrated civil legal services delivery system. Recent publications by Professor Corcoran include Bypassing Civil Gideon, a legislative proposal to address the rising costs and unmet legal needs of unrepresented immigrants, which was published last year by the West Virginia Law Review. Thwarting Justice, How Current U.S. Policy Fails to Hold Human Rights Abusers Accountable. And Obama's Failed Attempt to Close Gitmo, Why Executive Orders Can't Bring About Systemic Change, in the New Hampshire Law Review in 2011. She served as a professional staffer on the U.S. Senate Committee on Appropriations and was counsel to U.S. Senator Barbara Mikulski. Professor Corcoran also served as a staff attorney for Human Rights First and the Hebrew Immigrant Aid Society, and was a consultant to the UN High Commissioner for Refugees in Zambia. Professor Corcoran received her JD from Georgetown University Law Center and her BA cum laude from Montana State University. So thank you, and I'm going to hand it over to our panelists.
Great. I think Mark and I discussed, and we're both going to do present a little bit about what our scholarship is on, and then we hope that we can sort of turn it into more of a conversation, because I think the work that both of us are doing is around the same issues, and we have just a little bit of different perspective in approaching it. But before I get started, I just wanted to first thank UDC Law Review for hosting this really important conference and bringing just a tremendous amount of knowledge and experience in a variety of different subject matters here to the law school to talk about this really important issue. Megan and Robert, you've done a fantastic job, so I'm very excited to be here today. And I also wanted to thank Mark, because it was through Mark that I learned about this symposium and was encouraged to ask to see if I could speak on behalf of my article. So I'm really glad to be here today. And I think the last panel that came before lunch was actually a great segue into the issues that we're going to be talking about. Although they were talking about sort of the tax and housing context, I think there's a lot of similarities in the immigration context. So my thinking on this piece a lot comes informed from what I did when I was practicing law and representing immigrants before immigration judges, the Board of Immigration Appeals, and in some instances the Third Circuit. And one of the things that became really obvious to me early on was just sort of the lack of quality of representation I saw at the immigration court level. So while I worked for a nonprofit organization who prided themselves on really understanding what the issues were and making sure that they were doing a great job of zealously representing their clients, it became painfully obvious to me that there were a lot of attorneys in the courtroom that had little, if any, immigration law experience. Maybe were meeting their clients for the first time, signing retainer agreements as they were appearing before a judge, hadn't followed up on what the judge's requests were. And so in some ways I started to, as a person who had just graduated law school, started to have a sense of, well, what is so important or valuable about just a law degree, and why is it important that people have lawyers? Because I think that it is important that people have lawyers, particularly in the immigration context. But what I really began to believe, what more important than that, was that people have competent representation. You know, and when we were hearing about the post-conviction relief earlier this morning, you know, what constitutes competent representation? I mean, the courts is maybe someone asleep, or you know, so just the promise of a lawyer actually having a person who's admitted to a bar isn't necessarily always going to be what's in the best interest of an individual. And so in the current immigration system, there is a provision that allows for non-lawyers to represent immigrants in the administrative part of the immigration proceedings. So before the immigration judge, and then the Board of Immigration Appeals, which is the administrative appellate body that is housed within, both of which are housed within the Department of Justice. That individual has to be affiliated with a nonprofit organization that's providing legal services to immigrants for little or nominal fees. And that organization also has to be certified and accredited by the Board of Immigration Appeals. And then that organization then applies to, in fact, have an individual represent them, much like you would have in the immigration or the clinical experience, where you have a supervising attorney represent a lawsuit, a very similar kind of arrangement. And so we had several of those individuals working at the organization that I was at, and I was just struck by the amount of knowledge and experience that they had working in the immigration courts in New York and New Jersey, and appearing before judges and administrative hearing officers. They certainly had a lot more experience than I did, and I relied on them a lot when I was a young attorney in the office. And so it just started to get me thinking about how important they were, and they in fact are supervised by attorneys, and they only can appear at the administrative level. If our cases were taken up to the courts, then we had an attorney representing the individuals. And then we also began hearing a lot about something that is termed in the immigration world called notarios, which are people who, in a lot of Spanish-speaking countries in Latin America, in order to be a notary, you actually have to be a lawyer, and then it's an additional certification on top of being a lawyer. And in those countries, a notary who's notarizing a form is not just attesting to the identity of the person who's actually signing the form, but they're actually attesting to the underlying veracity of the documents. So a notary is a lawyer plus with a special accreditation on top of that. In the United States, a notary, as anyone can become a notary by taking an exam and paying the fee and taking an oath. And all you're doing as a notary in the United States is just making sure the person who's signing the document is who they say they are. So one of the phenomena we've seen crop up is these people who hold themselves out to be notarios. And they will oftentimes set up shop in immigrant neighborhoods with the word, Spanish-speaking immigrant neighborhoods with the word notarios. And many people think that they're lawyers. They're like they would be in their home country. They pay a fee, and these individuals are filling out forms either with misinformation, fraudulent information, and then these individuals are paying them and submitting these forms to immigration, and then oftentimes the information is incorrect, it's wrong, the person who would have otherwise might have been able to get a benefit is going to be now precluded because they've now misrepresented themselves in a federal immigration form. And in this capacity, these individuals are not signing as a lawyer, they're signing as a preparer. So, but there's been a lot of efforts, particularly with the ABA and several law firms around the country who have begun to work on a fighting notarial program, and what they're doing is they're bringing action against these individuals through consumer protection statutes. So you're either trying to have the FTC, which is the federal administrative agency that's charged with consumer protection, or going through the states to have actually there be some kind of lawsuit that's filed. So I saw this sort of spectrum of problems of sort of how do we make sure that if we're trying to get adequate information to immigrants who are being in removal proceedings, sort of what's the best model for that? And then, on the sort of where the immigrants are coming from, what's at stake for them is grave. You're talking about if you don't prevail in your removal hearing before an immigration judge, you can be sent back to a country where you may have never lived, where you lived for a very short period of time, where you have no family, no ties, your family might be here, and in certain instances you might be sent back to a place where you could be imprisoned, tortured, trafficked. There's a whole host of things. And while the Immigration Naturalization Act does stipulate that you have a right to counsel, you don't have a right to government-assisted counsel. And the reality is if you're here, oftentimes you're not allowed to work until you get an immigration benefit. You're unable to get any kind of public assistance benefits as a non-citizen. And so these legal service providers are attempting to fill a huge void, and it's incredibly challenging. The other thing that's also very interesting is sort of what's the odds? So there's been some really interesting studies, particularly in the asylum context, looking at what is the impact of having competent representation. The reality is you're 4 to 6 times more likely to prevail on your claim. So having someone who knows what they're doing appearing before a judge is huge. And so I started to think about, when I was working in the Senate several years back, we took up comprehensive immigration reform as one of the big issues on the table, and sort of looking at, are there other ways that we could potentially be trying to get competent representation through Congress for immigrants? And so my proposal is actually creating a fund that would be funded through going after notarios and actually finding them fees that would be collected would be put into an immigrant rights fund. And then that fund would be used to provide funding to nonprofit organizations that to hire accredited reps, because they're less expensive to hire than lawyers, that would be supervised by lawyers. And the idea being is nonprofits don't have the means themselves to actually pay for that, but if you increase the number of immigrants that would be represented, it would be better for all. So that's the basis of my argument. So I come at it a little bit of a different angle. I don't think that necessarily having a lawyer, just lawyer or not lawyer, is where the real difference is. It's whether or not you're getting competent representation. And I think in certain areas like immigration, that's very sort of an intricate area of the law. It's before a federal agency, so it doesn't differ state by state. And you've seen these models replicated in the U.S. Patent Office, so patent agents take a patent bar and are licensed by USPTO. You see it in the Social Security context. So there are other models of this working, having lay people with credentials and some kind of oversight capacity of that agency providing expertise in administrative agency proceedings with some success. So with that, I'll turn it over to you, Mark.
Thanks, Erin. Excuse me. I also wanted to thank the conference organizers before I start, particularly Christina, who runs UDC's immigration clinic and serves as my lifeline on questions frequently. And also Megan Challenger, who we had traded a lot of emails and was really helpful to me, and the rest of the law review as well. And also I wanted to thank Erin for her excellent article. So I agree, non-lawyer representation, it's not only worth considering, it's already happening. So, and not only in immigration courts in the US, as Erin mentioned, but in the UK, in Canada, in Australia, all of them have regulated non-lawyer representation in immigration court. And although there's differences in how those systems work, all of them have standards analogous to our lawyers' ethical rules. All of them have oversight through disciplinary proceedings. All of them have professional organizations, somewhat analogous to our bar associations. All of them require indemnity insurance for these non-lawyer representatives. Some have an exam that you have to pass, some don't. But as Erin also mentioned, in the US, not only do we have non-lawyers in immigration court, but of interest to this audience, we have non-lawyers in other US systems. Many of which have some of those same functions we see in other countries. In Social Security, there's some requirements for indemnity insurance. For the patent, to be a patent representative, you have to take a patent bar exam. You don't have to be a lawyer, but you have to take that. And workman's comp hearings in New York and other states. So I think what we're really seeing is this trend towards parallel non-lawyer representation, but with increased standards, oversight, and professionalism. So in essence, what we have is a trend towards institutionalizing a non-lawyer's bar, where the members of that bar resemble lawyers in most meaningful respects, except that they didn't go to law school. So, as to this trend, I think it raises some broader questions, and I'd like to discuss three today. Constitutional questions, pedagogical questions, and empirical questions. So, constitutionally, the adequacy of non-lawyer representation is most likely going to be examined in court for detained immigrants. And so the choices we make now to inculcate non-lawyer representation will inform that future court ruling. Pedagogically, that court ruling may have profound implications for the U.S. legal education model, because if a non-lawyer can adequately practice law, what value does law school add? And then third, following both of those, there's going to be a real need for empirical research. Can non-lawyers succeed as well as lawyers? At what skills? In what types of cases? Given how much education? Do they need 3 years? Do they need something less? So first, addressing the constitutional issues. As to the constitutional adequacy of non-lawyer representation, I'll give just a short preview of a future Supreme Court analysis, and specifically whether non-lawyer representation satisfies due process in immigration proceedings involving detention. It's a particular subset of the civil Gideon cases that John Pollack presented this morning. So as a quick background, the U.S. Supreme Court has actually sanctioned non-lawyer representation as a potential middle ground between no representation and full representation. And moreover, it recently expanded the types of cases in which a non-lawyer may be adequate. So previously, the Supreme Court has held that in cases that deprive one of liberty, that's a key case in which even in a civil, key situation in which even in a civil case you can get counsel. A non-lawyer representative such as a social worker might suffice for primarily medical questions. So in Vitek in 1980, psychiatric commitment, it's essentially a medical decision, and the court says assistance from a mental health professional can suffice and might even be preferable to a lawyer on these medical questions, so long as that person is independent and competent, which echoes what Erin said. In a follow-up case, Washington v. Harper in 1990, extends that reasoning to forced medication of criminal prisoners. Then in 2011, Turner v. Rogers, which the last panel talked about, it says that non-lawyers might suffice as an adjunct to those alternative procedures, and extends that Vitek reasoning beyond medical issues to simply factual, non-complex issues. Now that extension opens the door to non-lawyer representation in a wide range of cases. There the factual issue was indigency, it was filling out a form. But as anyone that runs a law school clinic or practices a case know, the line between factual and legal questions, or complex and simple questions, is very, very blurry. So in immigration deportation cases involving detention, these are cases that are particularly likely to raise this question in the courts of when non-lawyer representation suffices. It's a civil case, but it's depriving liberty through not only deportation, but detention, either prior or after deportation. There are advocacy groups currently preparing challenges now. The ACLU just hired a fellow in order to help establish a right to appointed counsel for immigration detainees. So within the next 10 years, we'll probably see these cases start going up. In a recent article, I argued that non-lawyer representation doesn't suffice for immigration detainees. So these cases, like tax cases, they're legally complex as can be. They're increasingly factually complex, particularly as immigration courts often relitigate the facts of a prior criminal conviction. You're litigating against a government counsel. It requires advocacy and litigation skills and presenting evidence, cross-examining witnesses. That said, it is not procedurally complex in one way. There are no rules of evidence in immigration court, like there would be in federal court. So when these cases reach the court, it's going to force a closer examination of when non-lawyer representation suffices, in what context, and requiring what skills, and when it doesn't. So what's factual versus simple versus complex? What's just filling out a form? Immigration forms can be extremely complex. In a lot of immigration cases, the form is the case and what evidence you attach to it. And what skills require a lawyer? Is it advocacy? Is it oral advocacy, learning how to prepare an oral argument? Is it evidentiary advocacy? Is it knowledge of the legal rules of evidence? So I think for civil Gideon advocates, which I know includes a lot of the people in this room, or immigration advocates, this looming court ruling advocates some of the strategic concerns we've talked about today. In a way, it's kind of the classic advocate's question. Do you push for half a loaf now, or do you hope for a full loaf later? But one thing to consider is that if there's a choice to push for half a loaf now, to expand non-lawyer representation, the court may enshrine that half a loaf into the Constitution in a case within the next 10 years. If the court takes that middle ground of non-lawyers, in a way it might be easier to take it if it can say, and non-lawyer representation already provides competent assistance to thousands of immigrants nationwide. So that's one, for advocates, that's a concern. Moreover, and I think more fundamentally, some kind of constitutional ruling on the adequacy of non-lawyer representation may have profound pedagogical implications for the legal education model in the US. So another way of framing the court's question is that if the only salient difference between the non-lawyer's bar and the lawyer's bar is going to law school, then what does law school add that ensures due process? Or rephrasing it for some of the current UDC law students in the room, what are you learning now that distinguishes you from 2 or 3 years ago, before law school, in constitutionally fulfilling your role as a lawyer? And so if one considers lawyer skills as the traditional 3 A's, analysis, advocacy, and advice, which can you perform better now that you couldn't 3 years ago? Or conversely, really the legal question, which can non-lawyers perform without having your law school education, at least constitutionally adequately? Is it analysis? Is it analyzing statutes and applying facts? Is it advocacy? Is it learning how to write briefs, orally argue, cross-examining witnesses in your clinic? Is it advice? Is it fulfilling your responsibility to the client? Is it the soft skills of communication and empathy? So traditionally, law schools have taught analysis, and they've only recently begun to teach advocacy and advice, although that trend has increased following the Carnegie Report and following, frankly, schools like UDC that have for quite a long time emphasized a more skills-based, real-world approach. Now, that said, preliminarily, and I would love to hear feedback on this from some of the advocates in the room or the folks who run the tax and housing clinic, often immigration advocates have told me that the main difference between non-lawyer representatives and lawyers isn't so much knowledge, but it's the professionalism and ethics that is inculcated as one becomes a lawyer. So people have said, you know, after a few years, and it takes a few years, as you know, with that experience, but you know, someone can read an immigration treatise and figure out the law. And to be honest, immigration law is so complicated that even if you took it in law school, which isn't required to practice immigration law anyway, you would never deal with the actual complexity you encounter in practice. It's just too technical. But the main difference, so I hear, is that lawyers, because we're inculcated in professionalism and ethics, we have a greater sense of responsibility to explain all the options. We don't just give a black and white answer, well, this will happen. We say, well, this will happen, but you know, there's 6 things that could go wrong. And as my duty as a lawyer, or maybe out of fear of getting sued for malpractice, or both, you know, lawyers, so I hear, tend to explain all of the, you know, we fulfill our ethical and case responsibilities to explain those options. Now, that said, professionalism and ethics can be inculcated outside of law school through bar associations or non-lawyer bar associations, through model ethical rules, through oversight, and we're seeing the non-lawyer models moving towards that. So again, coming back to the question, what does law school add that helps ensure due process? And so here's the implication for legal education. If a future court constitutionally sanctions non-lawyer representation as adequate, even in proceedings like immigration with complex legal and evidentiary issues, I think such a holding may essentially invite a return to the old 19th century apprenticeship model of legal training and undercut the traditional 20th century law school model. And so, indeed, the current BIA accreditation system in immigration courts essentially encourages on-the-job apprentice learning. It says one of the criteria is experience and knowledge of immigration and naturalization law, and the way you get that as a non-lawyer is by working on cases at an organization like HIAS or Legal Aid or one of those. So there's a real question as to the value of law school, and it comes at a time, which I'm sure as you all know, legal educators are rethinking the traditional models of delivering legal education, what value legal education provides, and students are rethinking whether to go to law school. One implication at least underscores that if your heart's goal is to represent immigrants, if such a ruling happened, you could do that constitutionally without incurring the 3 years of law school debt. Now, on the other hand, it's possible that the recent development of pedagogically sound skills-based education in law school clinics or schools like UDC or CUNY in New York, or increasingly nationwide, that emphasize skills and real-world practice, it's possible that that development may train better lawyers today in a way that traditional apprenticeship did not. And here I think is where clinics potentially play a key role. Clinics that teach client-centered, social justice lawyering through pedagogical methods that involve guidance, that inculcate self-reflection in you as a lawyer. And I know from the heads nodding that all of you at UDC have learned this. And so if the key lawyer's role, if the difference is really ensuring due process, if the difference is really the sense of professional and ethical obligations, law schools may do that better now than law schools did 50 years ago, and potentially that apprenticeship did 150 years ago. And maybe a future court, if it said that, law school is necessary to ensure due process, it might rest a ruling on those educational developments, as much or more so than the knowledge one learns. Or the court could implicitly or implicitly sanction some middle ground as to education, a one-year immigration JD, in which you take an immigration course load and you do skills training and you learn ethics and maybe you pass an immigration bar exam, like the patent bar. That's another option. As you all know, legal education is moving away from a one-size-fits-all model. We're moving towards 2-year JDs, limited license JDs. That could have constitutional implications as well. Third, and I'll wrap up very quickly, there will be empirical research, I think, needed to explore all of these questions. And I'll throw out a couple examples, and I think some of the access to justice advocates in this room are really the people that will do this. So the question, we don't know at this point whether half a loaf of non-lawyer representation is really half a loaf, or if it's closer to a full loaf, if it gets you most of the things that a lawyer do, or if it's a different loaf, if it's rye or pumpernickel, to extend an awful analogy. But to bring it back, is it better to have someone than no one? We wouldn't say that, it's better to have someone do surgery if a doctor isn't available. But, in the law world, there's always been, there are things paralegals do, there are things lawyers do. The line is very, very fuzzy between them. But there's not much empirical research out there as to whether, non-lawyers can perform as well as lawyers in immigration proceedings. Which proceedings? What ways? Which of the 3 A's of lawyer skills? Analysis, advocacy, or advice? So, first step, I think, there needs to be some quantitative empirical analysis of outcomes. Let's say in immigration proceedings. How do non-lawyers do compared to lawyers? How do non-lawyers do compared to pro ses? We know representation matters in immigration proceedings. We don't really know about non-lawyers. And Corrine, if you want to talk about what the Katzman group found, I would love to field that question. But right now, we don't really know. But secondly, we may need to get beyond that. Laura Abel has talked about something called process analysis. Not just researching outcomes of cases, but the tasks involved in litigating a particular case. Now, these are harder to examine and probably going to be more qualitative than quantitative. It's very hard to examine, is someone good at oral argument or not? Is someone good at cross-examining? Evidence is harder to get. It may involve, observational vehicles in court. Having people go into, or law students, go into immigration court, or lawyers, and observe. You know, one of the problems about conducting qualitative research on lawyers, if you ask a lawyer, are you good at doing oral argument, he or she will probably say, yeah, sure I am. So it's probably going to be some neutral observational vehicle. And thirdly, there'll have to be empirical analysis as to pedagogy. There may be pilots as to one-year specialized immigration law programs. Some of the limited license programs that are starting in Washington State. Other countries, Erin in her article mentioned some research in other countries as to immigration accreditation programs. All of this, I think, is going to be very necessary as we go forward. And, you know, a final concluding thought. So some in the access to justice community, they may be best situated to do that research, but there's also been a real reticence among the access to justice community as to having their methods of representation empirically analyzed. Because understandably, no one likes to have the value of their work called into question. I think, though, that these questions as to non-lawyer representation are unavoidable going forward. They're not only worth considering, but they're already happening. And I think and would love to see that if those in the access community would start to examine how lawyers and non-lawyers provide value and in what ways, I think it can only inform the debate going forward. Thanks.
Thank you. That was so interesting. And I definitely have questions, but I think I'm going to open it up to the audience first to see what kind of questions you guys have. And then there's microphones throughout the room in front of you if you need to use them.
So I have two questions, sort of concerns for you, maybe for you to consider as you're working through these proposals. One is, what about the...
Can you put that microphone on? Just reach down and push it.
Push it?
Hold it down.
Hold it down.
Till it turns green.
So one is, what about the cases, immigration cases, that require representation across institutions? So for example, when I represent an unaccompanied minor in a special immigrant juvenile proceeding, I do not represent that minor only in removal proceedings. I also appear on their behalf in dependency court and before the USCIS. Would a non-lawyer be able to provide that sort of comprehensive scope of representation? Because as I see it, all those things are part of an SIJ case, and it would be a very limited representation indeed if I said, oh, I can only represent you in an immigration court. And then additionally, I guess what I've observed, as you had posed the question, what's the difference, right? What I've observed as the difference between non-lawyer practitioners and lawyer practitioners are that at a certain point, the lawyers know when to call it quits and when to advise the client that I can't ethically present this case to the court because I have a duty of candor to the court, and I understand you'd like to pursue it, however, this is what it is. And those cases tend to be pursued for longer by non-lawyers because of sort of what I've seen as the social justice element, right? We don't want to give up on the client, whereas the lawyer's like, I have an ethical duty at some point to give up on this case. Anyways, those are my two.
I'll get started. I mean, I think that question that you raised at the end, I think is a question that I think actually would be served well by empirical research, because, you know, in my experience, which is obviously is anecdotal, I found working with, oftentimes I would get cases that, because we had a court referral program, so people would be at immigration court, they were looking for counsel, and cases would be referred to 4 or 5 nonprofit organizations who would do the intake and then sort of tell them, do we think you have a viable claim, and is it one that we're willing to represent you on going forward? And in many cases, there were applications that had been filed by lawyers that had given false information or misleading information about the viability of their immigration claim. So I don't think that that line between with candor is necessarily whether or not you're admitted to a bar and went to law school. I think there's something else there. I agree that there are lawyers who do that very well, and clients who are well served by that, but I don't know that. I mean, in my experience, I also saw it go the other way. You had these lawyers who would just prepare stuff, and they were admitted to the bar, and the judges knew it, and the ICE attorneys knew it, and everyone knew it, but they couldn't, you know, they would continue to file appeals, continue to ask for adjournments, you know, just keep pushing the docket out. So I don't know that that is, I mean, again, I think it's something that would be really worth exploring anecdotally. I mean, with research, I mean.
presumably, though, there's a remedy for that for lawyers, right?
Well, it's interesting. I mean, in theory there is, but in practice not so much. I mean, until very recently, there was not really much at all immigration judges could do. That's changed. The disciplinary rules and the ability for immigration judges sort of to refer people that are appearing before them. That dynamic is changing somewhat. But ultimately, it's usually the client that's going to initiate a bar complaint, right? And oftentimes it's not, these are people, if they get deported, they're not going to sue for malpractice. I mean, I think the dynamic in the immigration context is a little bit different than it is in a tort context. So I do think that although in theory, but just like in the accredited rep context, as opposed to just anyone appearing, it's the same kind of mechanism that the court would have with a lawyer. And I think arguably even more so because they're the body that actually gives them the license to appear before them. With respect to your first question, accredited reps can be certified to appear before your and before CIS. So with respect to the actual green card petition and the SJI application, that's something that an accredited rep could do both, and the CFR contemplates that. With respect to going to family court, state law proceeding, I think you're right. That's a little bit more complicated. And that's a state law question, right? So for example, I practice I'm barred in New York, but if I'm doing pro bono work in New Hampshire on domestic violence, a VAWA petition or something related, where I oftentimes am partnering with the New Hampshire barred attorney who's doing the state law piece of that claim. So I mean, I don't think that the only solution is you have to be able to do all of it. There's other ways to coordinate that, but if you're in the SIJ context, if you're going to try to get dependency proceedings, someone who's an accredited rep would not be authorized to practice law unless the state bar made an exception for that to happen.
Yeah, as to the question of collaborating across institutions, I think that's a great question. It really points up the need in anything. It's an increasing need in cases involving immigration generally, whether non-lawyers or lawyers. I mean, the paradigmatic example is criminal cases, post-Padilla versus Kentucky. For those who don't know, the case that said that criminal lawyers now have to advise about immigration consequences, mostly. So, for actually in a recent article I wrote that at least in some criminal cases that lead to immigration consequences, at least where they're involving mandatory detention, in 10 years, it might make sense for criminal lawyers to simply keep handling the immigration case, leaving aside funding concerns. I feel like I need to say that for all those who have worked in this room for the DC Public Defender or leaving aside funding concerns. But, as the worlds begin to collide more and more, that process has just happened. As criminal cases are getting relitigated, the facts are getting relitigated in immigration court, it may simply make sense for the lawyer to continue. It would certainly, in the very few cases where it's happened so far, it certainly has not hurt. I think getting to the second question, the discussion really points up, although we'd all like to have a civil right to counsel, probably if given the choice between a competent and ethical non-lawyer and an unethical lawyer, well, you can leave competence out, but the competent and ethical non-lawyer and an unethical lawyer, someone might be better off with the competent and ethical lawyer, or non-lawyer, right? Thanks. So as Erin says, the real problem with the immigration bar is that even with the usual protections that exist in the lawyer's bar, lawyers know their clients aren't going to sue them for malpractice. And that's there with non-lawyers and that's there with lawyers. One thing that Erin mentioned in her article is, a way of exploring ways to put that check on non-lawyers. One is having an accredited organization, a nonprofit, supervise the non-lawyer. And so maybe that inculcates some of that ethical duty, and maybe that addresses the question, when do you drop a case? When do you have a duty of candor to the court? Maybe there's criminal penalties, although maybe that dissuades non-lawyers from practicing. I think it's wide open at this point.
Yeah, I mean, one of the things that I actually thought about was whether or not it just made sense to just sort of license non-lawyers just generally, you know, just apply for a license. And I thought that there wasn't enough layers of currently the way that the system's structured where just, like a notario wanted to get licensed, I thought there was not enough protection for people at the way the system currently operates.
Before I take another question, I just wanted to, I noticed something that we immigration practitioners do a lot is we kind of revert to this alphabet soup of SIJS and CIS. And so I know not everyone here is an immigration practitioner, so if you don't know what we're talking about, please ask Mr. Leverett and we'll try our best to not use the alphabet soup.
Thank you.
Yeah, you're welcome. Go ahead.
I'm just wondering whether there's a middle ground in what Professor Noferi suggesting, in that what would happen if you allow non-lawyer representation under the supervision of a lawyer? This means that one lawyer might be able to handle 4 or 5 times as many cases as he would on his own using non-lawyer. So he would be there as a supervisor, just the way a clinic supervisor, I hope, supervises here.
Excuse me, Christina, as a professor in this room,
Yes.
the people in the back can't always hear.
Yeah.
Oh,
So you might
sorry.
want to ask if they heard a question, if not, repeat it for them.
Okay.
Ask people to try to use the mic.
Can you try to use the mic and restate
Yeah.
your question, please? Yes.
Since I don't hear well, that was a major,
Push it until it's green.
that was a major flub on my part.
Push it.
Pull it closer to you.
Yeah.
Okay.
You can pull it closer to you.
I don't know, I can't push hard enough. Okay, no.
Okay, that's good. You have to keep holding
Okay. I was wondering whether there's a middle ground of requiring supervision of non-lawyer representatives by a lawyer in just the same way that a clinic supervisor, I would hope, would supervise the people that work under her or him.
So I think you really hit the nail right on the head. That's one of the reasons, maximizing resources and increasing access to justice is one of the reasons people cite in proposing non-lawyers. And I think Erin cited that in her article, if I'm not mistaken. So I think I'll forward it to you, actually, if that's okay.
Yeah, I mean, I think that there is definitely, part of what I would contemplate would be supervision of non-lawyers by lawyers, and you can actually, I think the same way you see in the clinical setting, you actually would have the ability to sort of have more people on staff and the ability to sort of to take in more cases, and then to the extent that you have really complex issues, you have someone who has whatever that extra thing is that Mark's going to figure out that law school brings. It's the empirical stuff. But seriously, I think that having that additional layer on top of that is essential.
Yes.
I don't think I need a microphone. So 2 quick points. Well, 1 quick point and 1 quick question. First of all, Professor Noferi, I want to thank you for acknowledging that UDC has been long doing the practical, the clinical piece, because it seems that some of the legal journals and legal are suddenly discovering, and some of the other law schools are suddenly discovering that, and they're giving them ballyhooing them. We've been doing it for decades. So thank you for acknowledging that. But the second thing is the whole conversation about lawyer, non-lawyer, and the representation, for me, seems to become a value question on the client and the importance of the client. Because it's almost as though if it were a kind of higher value, you would want to have a lawyer. You would want to have someone skilled and went through law school and went to the bar. But because it's someone who is indigent, or it's an immigrant, or it's someone of lesser means, then they don't need someone as skilled, as trained, as qualified, and so therefore they can have someone of lesser qualifications. And so for me, it starts to sound like it's a question of value of the client and what society's, what they think of them. And so I'd like to just get your thoughts about that, because I'm not hearing about that when we talk about does everybody need to have, not to be represented by lawyers, and they can just have someone who is competent and an intelligent individual and just go to court and represent them. So I'd just like to get your thoughts on that.
That's a great question. So that's actually, I think, my primary concern about the non-lawyer system is exactly what you pointed out. It's the expressive value and to put it in legal jargon, of having non-lawyers. So it creates this system, if in appearance, if not in fact, in which criminal defendants get lawyers and immigration cases, even though the stakes are extremely high, and perhaps even more high than in criminal proceedings, you know, it's okay for non-lawyers to practice. You know, it's, or putting a really negative spin on it, you know, it's, you have lawyers for criminal defendants and pretend lawyers for immigrants. Someone could read it that way. I'm troubled by that, I think, as much as anything. And so I think putting aside, now that said, this is something, and thinking about what John said this morning, this is not a fully formed thought. I'm hesitant to call that two-tiered representation because in a way, you know, let's say a court said that immigrants get non-lawyer representatives. In a way, it almost would inculcate three-tiered representation in our current system. And I think this is leaving aside, you know, what John said about the various states that have moved towards civil right to counsel. But, you know, this is breaking down, but, you know, you have criminal defendants that get lawyers, you have immigration cases that get non-lawyers, which kind of echoes the Padilla construct of immigration consensus being not direct, but not collateral. And then you have civil cases that don't get anything. It creates that construct, except that that construct is already breaking down, as John was saying. You already have civil cases where, at least on the state level, there are courts which are saying, no, this is important enough that they get lawyers. You know, or the thing that I worry is that because immigration proceedings are uniquely about citizenship status, that's where it's two-tiered representation, where it's basically like, well, you know, it doesn't quite work this way because non-citizen criminal defendants get lawyers too. But I worry about the appearance that, you know, well, immigration consequences, because they're non-citizens, you know, non-lawyers are okay. That, I think, you know, it's a great question, and I think I'm figuring out myself how that is, whether that's worth it in the overall analysis. I think that's a great question, though.
I'd actually like to turn that. I'd like to sort of turn that around and think about what the client might find the most useful. And I think that in certain contexts, maybe having someone who has more time and who can maybe is used to working with immigrants, whatnot, non-lawyers, versus some lawyer who may have not had the experience in the immigration context could be more useful. And I was just wondering, I guess, if anyone has thought about that. There's also, I've heard of nonprofits where people sort of educate one another. There's a group in Puente, Arizona, where it's actually the community that provides legal education to one another. And I don't know, they do their own thing, but maybe they're providing something that, some sort of added value that actually a lawyer couldn't provide.
Well, actually, it's interesting. There's been a couple of empirical studies that have actually been done looking at the non-lawyer representation in the immigration context in both Australia and the UK. And what's actually interesting is what the studies indicate is that for a large part, the immigrants who are appearing before these administrative bodies are actually more likely to be candid with the non-lawyers than they are with the lawyers, because they feel like they're actually on the same sort of level as them, and they can relate to them in ways that they might be intimidated or feel a need to please a lawyer because they somehow see this lawyer as above them or having this more education. You know, for all of you who have done, including you spent a lot of time working on how do you create rapport and trust with your client from that very first interaction and make them feel comfortable. And some of the data that's out there seems to suggest that non-lawyers specializing in certain populations, as you've indicated, have a certain sensitivity to that population that comes with working with that population, and then a credibility that comes because they aren't lawyers or social workers or they're lay people trained. So I mean, I think it's a complicated question, but there is, I don't think again that it necessarily, the trust is going to break always on whether it's a lawyer or a non-lawyer.
Yeah, you know, there's actually an analog now in the development of community health organizations, post-Affordable Care Act. There's some movement towards having social workers, for lack of a better word, but they don't necessarily have to be doctors, but because, someone from the community who can, who has empathy, it seems to be very valuable.
Yeah.
What about from the judge's perspective? Is there any concern that the judge is going to treat a case with a non-lawyer representative differently than one with a lawyer?
You got to draw the microphone closer
I
to
can
you.
repeat the question if you want. I mean, what she asked is how does the judge react to these non-lawyer representatives? And in my experience, when they're attached to an organization that has credibility with the court, I watched judges appoint or asked BIA accredited reps to actually represent individuals in certain cases so I think that goes back to sort of the model that I'm looking at. It's not just any non-lawyer person coming before the court, but it's someone who has established themselves with an organization that has a reputation that the court has already sort of given some kind of license and accreditation to because they've had to establish. And that's not to say that things don't happen in ways. I mean, there's been cases where there's people that have been accredited reps who ended up doing a huge disservice to clients. But I think if you have that added layer of them being attached to an organization who's also is not motivated by profit, right? That they're working for nominal or free fees for their clients. And that's the other thing with immigration, as I'm sure with a lot of other things, to the extent that there's repeat players in the system, I mean, that's what I always tell my students is, the one thing you have as a lawyer or as a professional that you have control over is your reputation, right? And so to the extent that these accredited reps have a good reputation with the court, they're going to be looked to help the court, and they're going to have credibility with the judges.
Yeah, I had heard anecdotally that judges don't notice, that they don't look far enough down the G28 form when you file an immigration court to see which box someone's checked. It's just, someone's been in court a few times. They're like, okay. But I could be wrong.
My judges would notice.
Do that? Okay.
Yeah, they would notice.
Yeah.
Yes.
Thanks. I have several questions, but I have two, I think, at this moment. One is, I wanted to make a distinction on this question of who should be able to practice immigration law in general versus the issue of appointed counsel and who should be given or assigned to people that are in the removal proceedings. And I wanted to ask Mark to clarify in particular, when you're proposing the non-lawyer model, or at some of these various levels, are you talking about as appointed counsel, or who should be allowed to open a shop, and see someone for a family-based petition or a naturalization application?
Actually both. I mean, so non-lawyer representation already happens. I think the constitutional question will be, would non-lawyer representation satisfy due process? Does it do enough? Which is a related but different question.
Okay, thank you. And the other question was, now there are serious proposals that the immigration courts should get moved, out of DOJ and into independent Article I courts. And I wondered about the views of the panel if that should happen, and how might the fact that instead of an agency, you have a more structured, more formal, more rules of practice body, would that movement to an Article I system impact your recommendations?
Should I?
A tax court is an Article I.
Tax court is Article I. I actually wanted to ask the professors, can non-lawyers practice in tax court? Is it okay to have a non-lawyer accredited representative? That's something I don't know.
I don't see Professor Sheen.
Okay.
Actually, you can be a non-lawyer, but you have to take a particular test, and then you get approved to practice in front of the court. So there's a whole test that you have to take, and then you can practice in front of the tax court.
Even if you're a lawyer?
Well, once you're a lawyer, you just pass the bar. You pass the bar and you do that, but you can be a non-lawyer, you take a test, and then you can practice in front of the tax court, but it is an onerous test.
Okay, so it's like the patent bar.
Yeah.
It's, okay.
Which is also an Article IV.
Which is, right. I think that the question, it points up the larger question of what you learn in law school that is considered valuable to due process. So traditionally, that's very squarely been held to include procedural rules. You know, now traditionally it's been, you know, and even still, like as Erin mentioned, as a non-lawyer you can practice in immigration court, but once your case goes up the ladder and then has to go to the federal circuit, you need a lawyer. And I think even still in the proposal, yeah. So that's always been squarely been held to be within a lawyer's province. Now that said, the rules as to what's within a lawyer's province and what is not have always been written by lawyers. And you know, this is maybe not a surprise to the people in this room, but those concerns have historically been motivated by some degree of protectionism. And that lawyers are, you know, if non-lawyers start practicing law, it raises the question in our society of why do you need a lawyer and need to pay that money, which I'm sure is of huge interest to all of the people graduating this year in this room, as well as should be. I hesitate to give a very good answer. I would love to see an empirical study of non-lawyer accredited representatives as to how they function in immigration court, which has decently complicated procedural rules, if not the federal rules of evidence.
I guess the only other thing I would say is that, you know, in the tax context or in the Social Security context or in the immigration context, I think one of the reasons why it's viable, at least to argue that non-lawyers work, is it's a very sort of specialized area of the law. So as opposed to just sort of being a lawyer that's a civil litigator that goes into an Article 3 court, right, and is a lawyer of general practice. And so part of what you're being asked to do is sort of have skills that are transferable across topics and also understanding the mechanics of the process that gets you before the court, which is very different, I think, than understanding the complexities of a particular area of the law, and that's, you're limited to practice as a non-lawyer in that area. So I don't think that analysis changes whether it's an Article 1 court or it's an administrative body situated within an executive branch agency. For me, that's not really, for me, where the analysis would turn.
Yes, Jen.
I just want to start by saying thank you for coming. I think this is a very very important conversation to be having, especially in the context of detained immigrants, so thank you for being here. While I'm excited at the idea of increasing representation for people in front of the immigration court, I'm finding myself thinking of myself before law school and the things that I have learned in law school, not necessarily in my immigration classes or immigration clinic. For example, while the rules of evidence might not apply in the immigration court, they're certainly helpful for an advocate. And the processes of civil procedure and even the rules that you learn in crim law classes. To give you a specific example, I'm in a writing course right now where we're discussing the retroactivity of pre-ARERA relief for immigrants. And I'm wondering how someone would be able to analyze and apply those laws if they hadn't gone through the arduous task of having 3 years of law school.
I think that law school is an incredibly valuable thing, and I value my law school education, and I think there's things that, for one, it taught me how to think differently, right? It just taught me how to approach things in a very different way than I had when I was a philosophy major. And so, I think and it was a transformative process that sort of evolved over time and continued to evolve once I left law school. But I also think it's important to also just remember, practically speaking, when you're out practicing, even now, but particularly as a young attorney, there were tons of stuff that I knew nothing about that I had clients before me with. It's sort of part of being, I think part of the other thing that law school taught me, particularly through my clinical experience, was the value of going to other lawyers and asking for their counsel and sort of using the resources that are out there. And that you don't have to have all of the answers, you just know how to find the answers. And I do think that is something that can be taught to people who don't go through law school, showing them how to use the resources that are available, including using attorneys, right, to sort of help them navigate unfamiliar issues.
Yeah, I intuitively agree with everything you're saying. And it's animated a lot of my research. I feel like I was a better lawyer when I graduated law school than when I started. I feel like I was better 4 years out than 0 years out, and I feel like I'm better now 8 years out than 4 years out, and I hope I would be. Unless I'm one of those drunk or asleep lawyers that were being talked about this morning. It's an interesting question. I mean, part of, what I also found my clinical experiences very valuable in law school, and maybe that animates, my prior comments as to thinking that if law school makes a difference, it really may be the clinical education as much as the classroom learning. I think one of the really difficult things about this debate is drawing the line in the context of law school. And I think one of the reasons is that what we learn in law school, unlike medical school, I think is within all of us. And law school simply brings it out and hones it. As opposed to going to medical school when you learn the physical skill of performing surgery, which I am very sure I can't do. But the thing is, what law school teaches us, I mean, often it's, when we say learning how to think like a lawyer, it's that analytical skills, which everybody has, but it's honing those analytical skills and gaining that laser-like focus on attention and to procedure and to statutory complexity and all of those things which, once we become lawyers and once we practice, are why people pay us money to do things, to do things that people either can't or don't want to do, why we have value to society. I think one of the hard things about this, it's just so hard to draw that line because there's not something physical you can point to, like learning how to cut someone open. But I think, nevertheless, that it's still there. And that's, as I conduct my research, that's really what I'm trying to figure out and both having a hard time with at the same time.
So I know I'm not technically a member of the panel, but since we've been talking about, apprenticeship models and what's the line between practicing law and going to law school, and I'm barred in both Virginia and California, which will still have apprenticeship models of licensure. You don't have to go to law school to be a lawyer in either of those jurisdictions. You do law office study and with either a practicing lawyer or a judge for 4 years, I believe, in both jurisdictions. In New York, actually, you only have to have 2 years of law school and then you can sit for the bar. So. I think like Gary Glosser, he's the director of clinical education, or he was at UCLA. He never went to law school. So I think that when we're thinking about what do you learn in law school, are there alternative ways to, is there a middle ground? Can you be a lawyer without going to law school? I think the answer obviously is yes. And so how do we navigate that? So I'm sorry to shoot.
No, I think that's a great comment, and I think for me the other flip to it is that. What I don't think is looked at enough is that just because you go to law school doesn't mean you're going to be a good lawyer.
That's right.
And so for part of what informs my research on this is that you saw people who went to law school, learned how to think, and had a complete disregard for their clients' well-being, and were willing to take advantage of, exploit, defraud the system for pecuniary gain. And so I'm not sure that having that JD or even being admitted to practice in a state's jurisdiction gives you what I think how we would understand what a good lawyer is. That's just another point I'd like to know. Question.
Go ahead.
Hi, Erin mentioned a little bit about the cost of providing counsel, and I was wondering.
Can you pull up the mic a little bit?
Sorry. Erin discussed a little bit about the cost of providing counsel, and I'm wondering if there's any research out there about the cost of not having access to counsel, and if you do provide access to counsel, whether there's actual cost savings based on like the reduction in detention length and lower court continuances and everything that along the pro se client space.
I think there's been a little bit of research, so it's not very complete. There's something called the Legal Orientation Program. That's a program that's funded out of the Executive Office for Immigration Review. And what it does is it gives contracts to legal service providers, immigrant legal service providers like Catholic Charities, and law schools even can participate, in which they're going around basically giving information to detained immigrants about sort of the viability, not legal advice, but sort of information about sort of actually there's no way you can get immigration relief, because in some ways immigration law, there's not a lot of room for discretion. And that's the other thing you've also seen happening over time that I think makes this equation even different in some contexts is as Congress has continued to amend immigration, they've taken more and more of the discretion away from immigration judges to be able to make a call based on the evidence and the individual circumstances before them. So it's like if the facts go a certain way, there's only one way a judge can go. And so in some ways, these programs will advise these people that are detained that you don't have any viable relief. And in those circumstances, oftentimes those immigrants will go ahead and agree to be deported. And there is, I mean, the research isn't complete on this, and I think one of the other concerns is when you have these programs, can there be undue pressure that's placed on immigrants to go ahead and take the voluntary departure, when in fact there might have been a viable claim if it had gone beyond just the informational session and actually there was individual counseling that had gone on. So there's been some effort with it, but it's incomplete.
Yeah, I mean, I'll echo that. I think to your question, which is there empirical research that shows that counsel, increases efficiency in immigration courts and reduces detention, thus further increasing efficiency? I mean, the answer is not much. And for example, actually, the Administrative Conference of the United States, which is kind of like the policy arm of the administrative branch, they put out a great report on immigration courts. It was authored by Lenny Benson at New York Law School. And you'll see, actually, if you read through from the first draft to the last draft of the report, which hypothetically maybe I did, you'll see in the first draft that they started addressing some of those questions. And there, it basically said, anecdotally, it seems to, it stands to reason that if lawyers are there, it makes cases go faster. You don't have clients going home to get their documents, as the judge was saying in tax court. You have some, especially in immigration court, you have clients without any relief that if they talk to a lawyer and feel that they're heard and have someone say, I'm really sorry, but there's nothing we can do, they may choose to simply not be in detention and not have false hopes. But I haven't seen anyone quantify that yet. And that administrative conference study, in the first drafts they started to take it up, and in the last drafts you can see that they didn't get there. And I think because it's too complicated and too hard to quantify. But I would love to see someone do that study.
Yeah, because I think the best argument you could be making in the civil Gideon context, right, is that it's actually going to save the taxpayer dollar money. I mean, in any context, if you could convince Congress that actually paying for counsel in these would actually cost less money systematically, I think you would go a long way to getting at least a legislative civil Gideon, if not a judicial civil Gideon. Yeah.
I think we have time for one or two more questions. Professor Creel?
That question brought up another question for me, and that was, thank you. What about effective assistance and ineffective assistance, and what role does that play in this discussion? Maybe you don't want to have attorneys because if you do, there's a different standard between non-attorneys and attorneys.
Well, I mean, I think in the immigration.
Would you repeat?
Sure. I think her question was sort of what issues get raised in the non-lawyer lawyer model with ineffective assistance of counsel claims, and sort of is there different standards for what constitutes ineffective assistance? Well, actually, in immigration, the Board of Immigration Appeals and the Attorney General have sort of laid out the framework of how you even have to go procedurally about filing an ineffective assistance claim. And it's interesting because talking to criminal defense attorneys, right, where an ineffective assistance of counsel claim is filed, oftentimes the person who's being accused of providing ineffective assistance may be more than willing to cooperate with the attorney that's actually filing that claim because they really want their client, who's now has a different lawyer, to get out of jail. In the immigration context, in order to even begin to file an effective assistance of counsel claim, you have to file a bar complaint against the attorney and allow that attorney a chance to respond. So the stakes are a lot higher, and that is true at both ends. I mean, I think Lozado applies to both BIA accredited reps and to immigration attorneys. And so it's even harder to get an ineffective assistance of counsel claim. In the past administration, the Attorney General Mukasey had actually issued a decision saying that there was actually no constitutional claim, you could not make a due process claim to ineffective assistance of counsel in the immigration context. Holder rescinded that and sort of put the old framework in place and has charged the department with issuing regs to sort of figure out what the best model is for ineffective assistance. But it's not going to be governed by just sort of general common law. Immigration has very sort of particular pieces that you have to establish to even launch that claim. Let me take a look.
One more question. Go ahead.
I just want to follow up on a couple of things. And one, the analogy in terms of, and I've heard, it was said a couple of times about lawyers who graduated, went to law school, graduated, and they did wrong by their clients and they weren't really conscientious. I mean, that happens in every profession. There are a whole bunch of people who do very poorly and abuse the system, yet they don't throw out the system. They don't say, let's stop, let's just have, individuals start doing surgery and then replace the whole healthcare system. I think we want to be careful with that. The other thing is when we, Professor, when you talked about, all of us have that analytical ability and we can all become lawyers if we really tried. I don't know if that's exactly what you said, but I know I started out with some classmates a couple years ago. I think they all tried, but they didn't, and they're not going to graduate with me. So I don't know that that's necessarily the case. So to be able to develop and hone those skills, to be the good lawyer, to do necessarily what they need, I don't know that everybody necessarily has that. And as you're doing that research to get to that answer, I'd like you to try to add one other factor to it, and that's asking the individual who was represented by the non-lawyer and had a bad outcome, do they feel they would have been better represented if they had actually gone to a lawyer? Because most people would probably say, damn, if I'd only gone to a real lawyer, I might have had a better outcome. And so, at the end of the day, when you start thinking about ultimately who do we represent, it's the client. And at the end of the day, we as a society might think, what's in the best interest for the client as a society, but as attorneys, we have to start making sure that what we're doing is the best interest for the individual client. And that's what we're all here for, particularly at a public interest law school. We're going through this process because we know we're gaining the skills and the expertise and have the commitment, the ethics to know when to go, to know when to stop in the best interest of the client. And that's what we're learning for, and that's what we go to law school for, and that's why we develop the relationships with other attorneys. So in your research, if you just add that component in there as well.
Absolutely. Great points. Thanks.
Not too much to do. All right. Well, thank you so much for the great questions, and thanks again to our panel.